Bob Gammons. He's our first speaker tonight. He received his BA in economics cum laude from West Virginia Wesleyan College and attended Georgetown University for his law degree. He practices here in Huntsville. He's been a member of the Alabama Bar since 1977 and member of the Massachusetts Bar since 1974. He practices with the firm of Stevens, Millirons, Harrison, and Gammons, and they do general trial work, tort work, workers' compensation, fraud, real estate. It's a general service law firm. Bob has two children. Jason's age 16 and Sarah age 9. I've known Bob a good while, and he's a good friend of mine and a very accomplished lawyer. Tonight he's going to talk to us about mediation. Now, when I think about mediation, I thought about a story that I heard. I'm going to tell you real quick about these two guys that fought all the time. They were fighting all the time, and after one particularly bad fight, they found themselves in front of a judge. And the judge looked down at them, and they were all beat up, and he said, fellas, can't y'all resolve this out of court? Well, I looked up at the judge and says, Judge, that's what we were trying to do till the police interfered with us. Now, that's not what we're talking about in mediation. This is just a real brief definition. It's where the parties to a dispute would submit that dispute to an independent and impartial person to mediate and decide who was right. This is something that's coming into wide use in the courts in Alabama, particularly here in Madison County. And Bob has been doing this and been mediating disputes for a good while. So he's going to tell us about this form of dispute resolution tonight.
Thank you, Richard. I appreciate that introduction, and I appreciate having the opportunity to be here tonight to speak with y'all about a topic that is of interest to me, mediation. Mediation is something that has been around for a while, although not really very popular until probably the last year or year and a half here in Madison County. Alabama has had civil mediation rules since 1992, but I didn't know that myself until about 2 years ago when I first started to get interested in mediation and just what is it all about. Mediation in a civil case is a situation where, as Richard says, you have a dispute where an individual called the mediator is asked to participate in settlement negotiations. It's really settlement negotiations between the parties with the assistance of a third-party neutral called the mediator. Typically, the process is a voluntary one where the parties, or at least one of the parties, decides, well, I've had enough with this court process, all the discovery and all the lawyers. I'd like to get my case settled, and I don't want to wait for trial. What can we do to get the case moving on towards a resolution? One way to try to get it resolved is through mediation. Our judges here in Madison County and through North Alabama have been more interested and active in promoting the idea of mediation over the last year or two. And it's really kind of a nationwide movement that has built up steam throughout the country over the past 5 years or so. Some of the benefits of mediation are that it is a confidential process and it is non-binding. The mediator is not a judge, he's not an arbitrator, he's not someone that has any authority whatsoever to impose his mind on the parties that are involved in the dispute. It's the job of the mediator to try to come to an understanding of what the issues are, what the controversy is, and understand what the respective parties' beliefs are and their positions and their view of the facts in the case, and bring them together to some sort of understanding and resolution that they both agree to. It's not the job of the mediator to serve as a private judge and make a decision and impose that decision on the parties. One of the benefits of mediation, as I say, is that it is confidential, and it's a lot less expensive than following the litigation process through to a conclusion. Everything that is said in the course of a mediation or presented to the mediator individually or as part of a joint session is private and confidential by the rules of the court. It's considered to be a settlement negotiation and cannot be used in any further proceedings. So if the mediator is not successful in resolving the case, neither side can call the mediator to testify as a witness and say, well, on this day we had the mediation, didn't so-and-so tell you such and such. The mediator cannot be compelled to testify or to share anything that was said in the course of the mediation, and the idea for that is just to promote open communication between the parties in order to try to get an understanding of the case, to resolve the case. If a mediation doesn't work out, it's not successful, the mediator can't even report to the court why it wasn't successful. You can't say, well, Judge, this defendant just wasn't reasonable, didn't want to be realistic. All the mediator can do is report that the mediation was attempted on October the 1st and it was not successful. The mediation is a private proceeding. It's not open to the public. If you have a lawsuit filed in Madison County and it goes all the way through to a trial and you come in here to this room to try your case, anyone that wants to can walk in the doors and sit down and listen to all the testimony that's presented. They can walk over to the clerk's office and look at the pleadings that are filed, read what was alleged in the complaint, what the claim was, and read what the person sued says in defense. It's all open to the public. In mediation, you can have a free exchange of information in a confidential setting where the public is not invited and not allowed to attend. Typically, the parties and their lawyers are the only ones that are present with the mediator. So you have the benefit of some confidentiality where you can have your dispute considered by a mediator and hopefully resolved without being subjected to a lot of publicity. Now, what kinds of cases are suitable for mediation? Really, any kind of civil case. You wouldn't see a criminal case where someone's charged with a crime, whether it be a felony or a misdemeanor. You wouldn't see that typically in mediation. But any kind of civil case where there's a claim for money damages or breach of contract or what have you, a domestic case, you can see mediation in, and you are seeing more mediation in the domestic field. Any case where the parties are willing to attempt to negotiate a settlement is suitable for mediation, no matter how complex or how simple. Sometimes the complex cases are well suited for mediation in order to avoid the time and expense involved in getting a case like that tried. If you can have a free exchange of information, you can short-circuit a lot of the formal discovery process that we have in civil cases where you have a lot of depositions and hire a lot of experts to represent your side of the case, and the other side will hire experts to represent their side of the case. You can try to avoid a lot of that expense through the mediation process. It's a situation where you can try to preserve an ongoing relationship. If you have a dispute, say a landlord-tenant dispute, a long-term lease, and the parties know they're going to have to continue to work with each other even once the dispute is resolved, then you have reason to try to settle it without going all the way through to trial. You want to preserve that kind of relationship. Any kind of business relationship, a franchise dispute, for example, an employment dispute between an employer and an employee, anything where there's going to be a continuing involvement or relationship between the parties to the dispute lends itself to mediation because, again, the idea is the parties themselves will work through to a settlement that each side can live with and can understand is in their best interest. And that's the sort of thing that hopefully would preserve this kind of relationship that you're trying to preserve if there's a business relationship. Nowadays, we see in a lot of contracts a provision that requires an arbitration of a dispute that arises. It used to be in Alabama that a contract that you enter into that says if we have a dispute as we're going along in the contract, we cannot go to court, we have to resolve that through arbitration. It used to be that was not enforceable in Alabama. That's no longer the case. Now, if you have a pre-dispute arbitration provision in a contract, that can be enforceable. But that doesn't mean you have to go to arbitration, which is a private trial, if I can call it that, where you nominate someone called an arbitrator to serve as the judge and make a decision. Before you go to that arbitration, you can ask for mediation to try to settle it yourselves before you give up the right to make a decision to someone else. And really, that's what mediation is all about, is to maintain control of the final decision, the final outcome in the case. If you come into this courtroom to try your case, you're going to put these people in the jury box and they're going to make a decision for you. 12 people who may not want to be there to begin with, who've been summoned to perform jury duty, who don't know you and by definition don't have an interest one way or the other in the outcome of the case, you're giving them the authority to make that decision for you if you go all the way through to trial. But with the mediation, you retain the ultimate control. The decision whether or not I want to settle is with you in mediation. When do you attempt to mediate a case? Well, because mediation, one of the objectives is to promote efficiency and reduce the cost associated with pursuing a case through the court, you want to try to mediate as soon as you can in the court process. The sooner you can get started with a mediation, the lower your expense will be. However, there has to be a certain minimum amount of information exchanged in order to be in a position to make a decision. Do I settle or don't I settle? Is it in my best interest to settle or not? I don't know if you all have talked about discovery yet in your program, but there is a whole set of rules that apply to the discovery process. For anyone that files a civil suit, you can do a lot of things to obtain information from the other party, to compel production of information, to get copies of documents and records, to subpoena witnesses, to take depositions where people come and sit with a court reporter and testify under oath. All that is available as a way to discover information, but all that's expensive. If you can have a minimum of exchange of information so that both sides can understand what the case is all about, then you can go to mediate. There's no set time where mediation is appropriate or not appropriate. I've had cases that I've mediated right after the complaint was filed, literally, when there hadn't been a whole lot of discovery, exchange of information in a formal way. And I've had cases that I've mediated on a Friday before a trial was set for Monday. And there's a high degree of interest at that point in time in getting your case resolved so you don't have to go to trial. But when you wait that long, you kind of lose some of the benefit of the mediation by having incurred a lot of the expense already in getting to court. But you can mediate any time the parties are willing to mediate, when the parties feel they have enough information to go forward with the mediation. I've had cases where I've been a lawyer for a party, mediation's been proposed, and I've accepted on the condition that I get some additional information in an informal way without having to go through and subpoena documents. Things that I know are likely out there but I haven't seen, I'll ask be produced and then agree to go ahead with the mediation. So the key is to have a minimum amount of information available to fully evaluate your case. Now, how do you get started with mediation? One of the parties to the case can ask for mediation from the court, or this summer the legislature passed a statute that gave a judge the authority to order mediation even if neither party asked for it, and even if the parties are opposed to mediation. Except in some domestic cases, a judge now has the authority here in Alabama to refer a case to mediation under even a situation where neither side really says they want to try. How is a mediator selected? Well, typically, the mediator would be selected by the agreement of the parties or upon the suggestion of the court, selection of the court. Most judges have a list of individuals, typically lawyers, who are willing to serve as a mediator. And that list would be presented, and the parties would try to reach an agreement on the mediator. Again, the mediator is not a decision maker, so you're not picking a judge. You're just trying to pick someone who you think might be helpful in moving the case along towards a resolution. Someone that can promote communication from one side to the other in order to hopefully get the case settled. Alabama doesn't have at this point any kind of formal certification requirements for individuals who want to serve as mediators. Although there have been some standards that are adopted this year that require a person to register as a mediator starting in January of next year, there's no formal requirement for a certain minimum amount of experience in mediating cases or taking certain mediator training. All that's important, I think, in order to ensure that your mediator is qualified through either experience or training. But basically, anyone in Alabama who's a lawyer who has 4 years or more of practice can register to be a mediator, and once they have demonstrated through experience or through taking some courses on mediation techniques, they can be registered to serve as a mediator. In the domestic area, there are some separate rules for mediators. They're required to take some more specialized training for divorce and custody type cases that's a little more extensive than in the general civil area. But even there, the standards are fairly general, and again, all you're required to do is register. It's important when you're preparing for a mediation as a participant, as a party to the case, or as a lawyer for a party, to try to express to your client just what is involved in the mediation. Typically, the mediation would start off in the mediator's office in a conference room type setting. The parties would be present. Each side, each attorney would be given an opportunity to make an opening statement. Before that opening statement and before the day of the mediation, each party would typically submit something in writing to the mediator to give the mediator some background, some information about the case, so the mediator can better understand what the issues are and get right to the heart of the matter. The purpose of the joint session where you have everybody together there are many reasons for that joint session. That's a very important part of the mediation process. The mediation is designed to give each side what I like to call a low-risk opportunity to see what the other side has to say and how they say it. When you get involved in a civil case, you do a lot of things with your own lawyer. You do a lot of talking with your own witnesses and the people who are on your side of the case, but a lot of times you don't really get a good appreciation for the other side and what they're saying, except what's filtered through what your lawyer tells you. And there's nothing wrong with that. But you all know from your experience that a lot of times the way something is said by one person can be construed differently from what someone else says. So if you get in the same room in a mediation where you're not going to be forced to resolve the case against your will, and you can sit down across the table with that person who you're suing or who has sued you and hear what they have to say themselves, that can be an important catalyst in getting the case resolved. The only other time you get that opportunity is when you're here in the courtroom. And even when you're here in the courtroom, you're hemmed in by the rules of evidence and what your lawyer says you should say and what your lawyer says you shouldn't say. You don't really have an opportunity to express what you want to say when you're in trial. But you do in mediation because it's confidential, it's private, and if it doesn't work out to your satisfaction, you don't have to settle. So the benefit of mediation is to give you an opportunity to say what you want to say to the other side and to hear what they have to say in a way that you don't risk someone else called the jury making that decision for you.
How does it come about that it gets to the judge to the level that he says you mediate rather than just voluntarily?
Typically, when the judge is looking over their docket, they'll set cases for a pretrial conference where they meet with the lawyers. They try to find out a little bit what the case is about, and the judge will typically ask, have you thought about mediation? Some judges will require pretty much all civil cases that can be referred to mediation to go to mediation as a way to weed the cases out of their docket that aren't really suitable for trial, where the parties don't really want to go to court but have no choice but to proceed. So typically, as the case moves along, unless a party or the lawyer for a party suggests mediation, the judge will pick it up before it gets to a trial setting and suggest it himself. I mean, it varies from judge to judge. Over in Marshall County, I think for some time, judges have been requiring most cases go to mediation, even more so than our judges here in Madison County. It's important for you as a participant in a mediation to understand that this is a good opportunity to have your say. If you're angry about what has happened, to say to the other side you're angry and why. If you're the defendant in a lawsuit and you really know it's your fault, you ran that red light when you shouldn't have, or you looked over here and you went through a stop sign when you shouldn't have, your insurance adjuster says don't say anything to the other side. Don't even tell them you're sorry. Mediation is a great place to look at the person and say, I'm sorry. I wish it hadn't happened. I didn't want to hurt you. It just happened. You can say that in mediation because those words can't be used against you in a further proceeding if you're not successful. And it's pretty therapeutic when you're on the receiving end of an apology like that to say, well, now I can start to get beyond my hurt and get this resolved. I've heard the other person say from their heart that they are sorry. Now I can settle. I had a death case not long ago, very serious case, where an apology was one of the most important things that could have been said in a mediation, and as soon as it was said, the case pretty quickly was settled. The issues in the case weren't dollars. It was just an understanding that the other side recognized and acknowledged that what they had done was wrong, and although they certainly didn't intend to hurt someone or to kill someone, they were sorry. In this day and age, we all too often, rightly or wrongly, are afraid to say we're sorry. Mediation gives you an opportunity to do that.
How typical is it for both sides to have an attorney in mediation?
I require it as a mediator. It's very important, I think, if you're represented by an attorney, to go ahead and have the lawyer there. Even though I'm a lawyer myself, I try not to walk into the room when I'm mediating a case and presume to give someone legal advice. I rely on the attorney for each of the parties to work with me in explaining what the law is as it relates to a given point in the case in order to understand why the law is important in terms of what the potential outcome would be. So I don't want to, as a mediator, give someone legal advice without their lawyer there to hear it and to say, well, I don't quite agree with that. I think the law is more over here. A lot of times in mediations, I've had mediations because the lawyers perceive that the client just doesn't want to understand what the other side is saying. And they have difficulty, and I can tell you from my own experience, it's difficult when you work with a client who has a case that they think is a good case to talk with them about some of the downside, some of the things that could go wrong if you go into court and try your case. They look at you and say, well, whose side are you on? You're representing me, not them. Don't tell me all the bad things. That's where a mediator can help. Explain and reinforce what the lawyer has hopefully already started to talk with his own client about, so that the client, through the mediation process, can get a better appreciation for, well, there's another side to this whole case. Or the law says in this kind of situation, I may not be entitled to the relief I think I'm entitled to. And nobody can do anything about that, but that's what the law is. Sometimes if the lawyer has said it and then the mediator comes in and tries to suggest the same thing, that's helpful in getting a case resolved. So I've had cases where lawyers have wanted the mediator to kind of be the bad guy from the standpoint of bringing reality back to the party's understanding of the case. And the mediator can do that because they're not a decision maker so long as they're not perceived as taking sides. The last thing you want to do as a mediator is be perceived as being an advocate for the other side. You have to walk kind of a fine line and say, well, not what I think, but the other side tells me this about the case, or I understand this to be the fact as they perceive it. Now, if the jury believes that, then it may be that the outcome of the case is not going to be to your liking. It just kind of reinforces that there's another side to the story in the case. In a mediation, the lawyer's job is to talk not to the mediator, but really more to the other party, to promote this understanding that I've talked about. Typically, I think that a lawyer's approach in a mediation should be more conciliatory than aggressive that you might see in a courtroom setting where you're trying to play to a jury. Your audience in the mediation is the other party, someone who walks into the room not really wanting to hear what you have to say. So you need to be a little bit more adept at approaching the case and to talking about the strong side of your case to get that communicated to the other party so they can intuitively understand, well, there is another side to this case and I better rethink what I think this case is worth. It's a good idea when you're representing someone to meet with the client ahead of the mediation and talk about a settlement range, what this case is worth, and to expect that there's going to be some numbers going back and forth, and to be flexible in your approach to evaluating the case, to keep an open mind in order to try to promote settlement. After the joint session, when everybody has an opportunity to have their say, the mediation would separate into what are called caucuses or private sessions, where you'd go, typically the mediator and the plaintiff and the plaintiff's lawyer would talk further, find out more about the case, some things that maybe the plaintiff's lawyer didn't want to say when the defendant was present, but yet are important to understand in order to get a good grasp of what the case is all about. The mediator can do that with both sides in an effort to understand what the case is about and then communicate from one side to the other and serve as a buffer. If, for example, you have a fraud case and the plaintiff has good evidence of some real clear deception and cheating on the part of the defendant, it's a little easier to carry that message indirectly rather than look across the table and say, you cheated me and I want compensation. People don't react too well to being called a cheater to their face, but if the mediator comes in and says, I understand from Mr. Plaintiff that this is what happened, and if that's what the jury believes, then you may have some exposure. You may be liable for some money. So you need to think about that in your evaluation of this case. So the mediator's process is to try to get some understanding on both sides and to keep the lines of communication open so you don't get one party upset with the other and just throw up their hands and walk out of the room. So you separate them and try to do this shuttle diplomacy, I guess is one way to call it, to get the case resolved. Mediation is a very useful technique in resolving cases. It can get your case resolved a lot faster and a lot more efficiently and cheaply than if you follow through all the way to trial. It can preserve an ongoing relationship, as I have already mentioned, that is worthwhile in preserving either in a business setting or I mentioned the domestic setting. Certainly when there are minor children involved in a divorce, there is a real need to keep those lines of communication open rather than to come into court and drag out all that dirty linen in front of a judge. It's better to try to promote a negotiated settlement that both parties can themselves understand is in their best interest. Mediation is very flexible in terms of the kinds of outcome that you can reach. If you have a case that comes all the way to court, most of the time a jury can only return a verdict for the plaintiff or the defendant, and if for the plaintiff, how much money to award. Well, maybe money is not what the plaintiff's really looking for. If you have a dispute over employment and the plaintiff has lost their job and thinks that they're entitled to have it back, the jury can't force that person back to work. But through mediation, if the mediator can pick up on that being the real motivation of the plaintiff, he can talk with the defendant about what their exposure might be and how it might be in their best interest to go ahead and give them another chance to put them back to work, maybe in a different job or position. But yet, there's some more flexibility there in the mediation setting that you don't have if you go all the way through to trial. Mediation, even if it's not successful, is a great way to get a better appreciation for the merits and value of your case, whether you're the plaintiff or the defendant. You can't help if the mediation is entered into in good faith to walk away from the room with a better appreciation for your case and what might happen. It's not at all unusual for a mediation to be attempted and to not settle on the day of the mediation, but if you can get some momentum going, some understanding on the part of both parties, many times you'll get a call back a day or a week or a month later. I had one yesterday, a case I mediated 2 months ago, finally settled. And the lawyer I talked with said, I appreciate what you did. It got us on the right track. It just took a while longer than I expected, but we settled. We didn't have to go to court because of the enlightening way the case was considered in the mediation. So even if the case doesn't settle, that doesn't mean it won't ever settle if you can get some momentum going in the right direction.